Ms. White?
Thank you, Your Honor. My name is Jane Larman White. I appear today on behalf of the defendant, John Beaudry, on appeal of his several convictions of sexual assault. There were two jury questions during deliberations. One included a request for reinstruction on reasonable doubt, and a second requested documents which had been marked for identification concerning the credibility of the complaining witness and her mother.
What were those documents?
The documents are hospital records from Florida, which impeached the testimony of the two witnesses at trial. I would like to go in some detail into the facts because of the legal issues here. A child who was somewhat over 9 years old was sent to Massachusetts to live with her father, whom she never knew. She came in August of 1998, and in March of 1999, she said her father touched her with his thingy, and this allowed her to go back to Florida. She did go to Florida, and shortly thereafter, she was involuntarily committed to a mental hospital. There was no report of molestation in Florida or in Massachusetts to law enforcement authorities until the mother refused to let her come home from the hospital, and the complaining witness again made the allegations and obtained permission to go home. At trial, she certainly did allege sexual assaults in some detail. No defendant can prove that something like this did not happen. This defendant can't, and no other one can. All he can do is point to indicia of untruth or a lack of credibility. And up front here, I would like to say what permeates this whole case, I believe, on appeal certainly, and at least in the prosecutor's mind now and below. The defendant had a prior record of sexual assaults on an older daughter. I'm putting that up front. I want you to not apply a sliding scale of due process or evidence based on that fact.
He testified, did he not?
He did.
And I take it this was not used to impeach him?
It was not. In fact, there was a motion in limine before trial, and you have the transcript. It's a May 15th transcript a couple of weeks before trial. The Commonwealth wanted to put in evidence of those prior convictions and prior activity, actually, not just the convictions.
Claiming that they were virtually identical.
That's right. The judge ruled that they would not be admitted. The defendant did put forward evidence at trial and impeached on the traditional grounds. The complaining witness changed her stories. First, it was he touched me with his thingy. Then in Florida, she said it happened 3 times, but there was no narrative of any sort and no detail. By the time of trial, it had happened 2 times a week for 6 months, and there was a lot of detail. The defendant proffered that there was a motive for the complaining witness to make up this story. She wanted desperately to go home to Florida, and the first allegation came on the heels of her mother's refusing again to allow her to come home.
Come home to Florida.
Home to Florida, yes, where her mother and 2 sisters lived, and it's the only home she'd ever known. The second time she made this allegation apparently was when she was in a mental hospital in Florida. And again, it obtained her release from the hospital and allowing her to go home. The defendant posited and introduced evidence by way of impeachment that the child had not complained to any number of people in Massachusetts, to her grandmother, to her half-sisters with whom she acknowledged a very close relationship and saw them at least 2 or 3 times a week and had dinner with them, to her aunt by marriage, who considered herself to be a mother figure to the child, and who testified at trial as well. And Aunt Terry said that she was called as soon as the allegation was made and went and talked to the child and said not only did she want to act as a mother, but she wanted the child to know that she herself had been sexually abused and that she had children who she wanted to protect from the defendant if he indeed was a sexual abuser. To the aunt, the complaining witness said that, no, she just wanted to go home. It had not happened. The Commonwealth claims as to both that witness and as to any number of other witnesses, the fact that the complaining witness talked to her mother by telephone at least 2 or 3 times a week. She talked to friends in Florida. She had regular appointments with a counselor or a psychotherapist. She had guidance counselor at school. She had teachers at school. There were no complaints to any of those people. The Commonwealth claims that, she was always, that Aunt Terry would be associated with the defendant, and not a protector, and also that she had no way of making a complaint outside the presence of either her father or her grandmother. But in fact, when the complaint was made, her grandmother had called the mother to complain about the child's behavior, and the child merely said, "Get off the phone, grandmother, and I want to talk to my mother." And the defendant would suggest that she had the wherewithal to make a complaint to her mother if these things had happened. The defendant also introduced evidence of recantations, not only to Aunt Terry, but in a rather convoluted way, to the mother at home in Florida, although the mother testified repeatedly that the child had never recanted at any point. The child herself acknowledged recanting, at least in Massachusetts. And the Florida police officer who confronted the mother and said, "Did this happen? Why didn't you complain?" She said, "Well, the child continued to say it didn't happen. It never happened," when she got home to Florida. As is apparent in the brief, and as it is apparent in written proffers and the May 15th transcript, the defendant, who had obtained permission to look at records of the complaining witness's psychological history, knew that there was a great deal of evidence that would lend support to refuting a Commonwealth claim that when she went home to Florida, she was very messed up, and it was because of this horrible abuse in Massachusetts. And he said explicitly and repeatedly in both writing, and this is in the record appendix documents where he was making his proffer for the admissibility of the records on the following grounds, that he wanted to guard against any claim by the prosecution witnesses or the DA that there was a change in behavior which corroborated the truth of the assertion of sexual assault here in Massachusetts. He said it over and over again. When at trial he sought to confront the witness, the mother, with such evidence, the judge ruled that that would not be permitted because it wasn't close enough in time. Nonetheless, against this background, the Commonwealth, the district attorney, argued in closing that believe the complaining witness because her behavior had changed. In at least two ways, she cited, these two ways were the subject of objections. The prosecutor said that the behavior had changed because she hadn't hallucinated before and she wasn't suicidal before. But in fact, the records refute that. I understand that the court revised its order allowing further appellate review, and you don't want to hear about the admissibility of the records. They're germane nonetheless because of what the prosecutor argued. And I believe that that's clear in the brief and in the allowance of further. In the ways pointed out in my brief, and I had the leisure to go through the records and have them ready and have them paginated, frankly, in a way that they were not in the trial court. As is apparent from the May 15th transcript, the parties were having a very difficult time going through them because, as I know, because when I went to look at them, and my sister would know, there was a pile, and they were not paginated in any way. They weren't stapled together. There were various sources of material, but they were all just jumbled together. As you can imagine...
Isn't the case here solely on the point of whether the prosecutor could argue that the child's testimony should be, the victim's testimony, alleged victim, should be believed because she displayed knowledge that was inconsistent with her age and could only have obtained it by reason of contact with the defendant?
That's not my understanding, if that's what you'd like to hear about. My understanding is that the prosecutor's closing argument overall is what is the subject of further appellate review. That's my understanding. If that's your understanding, I'll certainly get to it.
Well, I don't know. Did a specific order go out saying it's
limited to the closing argument?
Closing argument.
In general.
In general, and as I would like to say, there are three portions of that closing argument. The Ruffin inference is one of them.
The Ruffin thing, yeah.
Yes. I'll skip ahead to that if that's, in fact, your interest.
Well, I don't want to tell you. If it's the whole closing argument, you can,
Okay.
It would be helpful if you
can use your 15 minutes any way you want.
It would be helpful if you addressed the Ruffin argument.
Okay.
What occurred is, as I understand it, is sort of the reverse of the usual Ruffin thing, right?
Yes, yes. That Ruffin was written and promulgated as a shield to protect defendants against the tendency of a jury to believe that the only way a child complainant, a child sexual assault complainant, would know of sexual assault and know to testify to it would be from having experienced it at the hands of the defendant.
Yeah, and under Ruffin, you can show that the victim learned it somewhere else, either
Yes.
from prior abuse or whatever.
You have to do
Now,
that.
here it's the reverse. They're saying she learned it only from the defendant.
Under Ruffin, you have to make a motion. You have to show that the child has sexual.
That's in part because you're having to overcome the rape shield statute, and which has always been, had all kinds of. It seems to me the premise of Ruffin is that in the absence of any information about some other source, it is in fact a logical inference for the jury to draw, and the concern in Ruffin is they're going to draw it, even without argument, potentially. They're going to draw it, and that's potentially unfair to the defendant if, in fact, there is some other source, and the defendant needs the necessary tools, including, where appropriate, and where the requisite showing has been made, to get around the rape shield statute.
Well,
But that seems to me doesn't take away from the underlying logic of the inference.
There are two answers to that. One is if you follow the line of authority since Ruffin and just shepherdize Ruffin, you will find from both this Court and I think largely from the appeals court that the defendant did not make it the requisite threshold showing that the child had knowledge beyond her years, that is a primary basis, and that's only a part of the rape shield law, that it's sort of, you wouldn't get that inference from the jury if the child did not display sexual knowledge beyond her years. And in fact, there's case law that sort of says what is or isn't, mostly what isn't, because the defendant's arguments in this regard were denied, and that these were not things beyond a child's years. And those cases are cited in my brief. Savage is one, Rathburn is one. I also correspond the ages of those complaining witnesses with the complaining witness in this case and talk about how if in that case a child of a given age didn't display unusual sexual sophistication by using the identical terminology that this child used, then this should never have come up at all. It's the question of whether it's a logical inference. For the reasons stated in my brief, there was no evidence as to what a child of this age would or wouldn't know. And as I've indicated, prior case law suggests that the terminology and expertise she displayed was not unusual for a child her age. But beyond that, the explicit objection made was that there's no evidence as to what this child does or doesn't know. There's no expert testimony on what a child her age would know. And as I have further stated, the record, although it was not before the jury, demonstrates that this child was perhaps not a typical child because persons had taken pains to tell her what sexual abuse was. The people who had done that were the defendant, the defendant's mother, and the defendant's older daughter, who herself had been the victim of sexual abuse. It was at the defendant's behest that the older daughter and prior victim spoke with the younger daughter about this shortly after she arrived.
She was the victim of the defendant.
Yes.
Am I correct?
But she's now older and has children of her own. And from all that appears in the transcript and the record, they were on very good terms. She lived just up the street. She, in fact, dined with the complainant a couple of times a week, and that was one of the people to whom the child made no complaint during all this time, although that was the person who had told her about the sexual abuse and told her to guard against such abuse by anyone. The Commonwealth's essential premise now on appeal to avoid the consequences of this tactic is to say that even though a child this age wouldn't know about sex and what that meant, that a person explaining what sex abuse was and how to guard against it wouldn't include in that explanation an explanation of what it was you were supposed to guard against. And that is just an inconsistency that does not withstand scrutiny or logic.
I take it we don't, because obviously the whole subject was excluded from the trial, one of the things we don't have is specific evidence, or much specific evidence, about precisely what that conversation entailed and how much or how little graphic detail the older victim did in fact convey as part of this warning. We
And
just
that's
don't know, right?
That's certainly what the Commonwealth would like to hang its hat on, that when, in response to leading questions, and it was only the investigating officer who gave this testimony. This wasn't an invention of the defendant who put this forward. It's something that is in the record, and I could find it and show it to you because it's in the record, although not for this purpose. The grand jury minutes were part of the record for other reasons and not before the jury. But as to that, the follow-up and leading question was, well, it wasn't much detail, was it? And he said, oh, no, it wasn't much detail. But in fact, in that summary...
But I take I'm sorry, even that is a hearsay source. In other words, we don't have
Exactly.
testimony or an affidavit or anything
From the sister, for example.
From the sister saying,
Right.
here's precisely what I told her,
No, because
for either
this-
you or us to assess.
Because
Is
this
it
was
detailed or
something
not?
that, this was a burden that was imposed upon the defendant after the evidence had closed in any event, and it was a subject from which he obviously wanted to stay away based on the motion in limine and obvious responses to that. I know my time is up. I'd like to make one point. It's that the Commonwealth seeks to convert the closing arguments issue into an instruction issue, and saying that the failure of the defendant to object to the instructions means that there's a different standard of review. There's a case, Commonwealth v. Kelly, 417 Mass. 266, which directly contradicts that. For preservation, after an objection to the argument, you're not required to object after the charge. And furthermore, the standard is where it cannot be said with assurance that the improper argument could not have influenced the jury to convict. For all of the factual reasons I've started this argument with, I say that the three errors in closing argument certainly affected the jury's consideration. Thank you.
Thank you, Ms. White. Ms. Petrus?
Good morning. May it please the Court, Judith Ellen Petrus, Assistant District Attorney for the Commonwealth. What this record does, in fact, show is that the defendant, at the time of trial, did not have any argument or dispute the fact that this particular victim had not been given specific information from his elder daughter, his first victim. And I would direct the Court's attention...
Ms. Petrus, I'm sorry, you have to say that again because there were two negatives in there, and I just have to figure out if I'm understanding you.
Yeah, what do you mean?
Okay. The defendant at trial,
Correct.
the record shows, did not dispute that his elder daughter, his first victim, did not give specific information to the second victim.
Which means?
I mean, why would
How
he
did
do
it even
that?
come up? I mean,
How did it come up? Yeah.
Given the motion in limine, I'm puzzled. I mean, I haven't read the whole transcript yet.
The way it came up is that at the time of sentencing, the defendant did tell the Court that there was a dispute as to whether the mother of this victim had been aware of the fact of the prior molestation. He clarified that, but he did not dispute the prosecutor's statement that no specific detail about the prior molestation had been provided to the
But
victim.
this is all post-trial, correct?
But it's contemporaneous. It's
No,
not.
but it doesn't, I mean, what you're doing at a sentencing hearing is not what you're doing at trial. We're looking at the closing argument at
Correct.
the trial.
But
So,
a fundamental premise on the closing argument attack is that, in fact, there was another source for this child's sexual knowledge.
But you do that when if somebody wants to have the, leaving aside the rape shield law, I thought the law was pretty clear that if you want to make that argument, it's usually been in the other direction, but there has to be some kind of threshold showing. And that's during the trial. This was a closing argument. And so what the defendant is doing thereafter doesn't go to this point.
Well, but what the defendant is acknowledging thereafter underscores the fact that there was here not even a suggestion of prosecutorial misconduct or misstatement of a material
Ms. Peters,
fact.
I know you keep saying that, but you're really asking us to look at different we have to look at the closing argument and have to look at what happened up until the closing argument, not what happened afterwards.
But in this instance, because there wasn't a motion for new trial to develop further that which had been excluded at the defendant's behest in the motion in limine, what the Court is left with is a record that is at best spotty. What the Court
Where is the proof in the evidence that permits the prosecutor to argue this? What evidence shows, first of all, that she, how old was she when this happened?
9,
And how old was she when she testified?
12.
So she's 12 when she's giving this kind of graphic
Correct.
testimony.
She's
there any-
9 when she's giving detailed information to the police officer in
Any kind of
Florida.
testimony that shows perhaps a 9-year-old wouldn't have this kind of knowledge from any
Well,
source?
I think that's a question of fact for the jury as to whether, in fact, this particular child, it's going to differ from child to child, community to community.
Wouldn't you need some expert testimony, though, for the jury? I mean, frankly, I have no idea today what a 9-year-old knows. I
Well,
mean,
I
it's so
would
different
suggest that it's
from when I
highly
was young.
influenced. I mean, it seems to me that we can't stop the jury from making its own inference. It's very different for the prosecutor to say, this is the inference that you can and should draw, when
Well-
there's no basis for that inference.
But there is, by virtue of her demeanor, the way she spoke to the jury, and also her age at the time of the events when she first gave the detailed information. And that's a reasonable inference that could be drawn and could
Why-
also
no,
be
but you
rejected
just-
by a jury.
But what if
And I
it's,
take it she was asked whether she herself had any prior sexual
Correct.
experience.
And
No other
she-
possible source, but just her own.
But there are so many other sources. You hear it on the street, you hear it from girlfriends, you see it on television today.
There
I mean,
was
there are
no
tons of
indication in the
sources.
record that she heard that from
But there's
girlfriends
no
or heard it.
basis, but the prosecutor argued that she had no basis for the knowledge other than if it happened. And the record doesn't support that with that one question about whether anything like that ever happened to you before. That doesn't support the argument, because she could have learned it from 10 other ways.
Agreed. She could have learned it from 10 other
Okay,
ways.
so what in the record supports that argument?
Put it this way, Ms. Pierce, we let defendants do it if they can show, I mean, we let the argument be made, that the negative argument, that you can't draw the inference because in this case, this is what happened to this child. It seemed to me a very different stretch to say that we can draw any inference. I don't know what is available in Florida. I don't know what they watched on television. I mean, I've said this before. Unfortunately, there's all kinds of information that is available in ways we probably would be astounded and shocked.
The fundamental premise of the whole Ruffin approach, allowing a defendant to rebut this inference, is that it's automatically an inference that's in the case, depending on the particular child who is the complainant. Here it was a reasonable inference that could be drawn, not necessary, not inescapable, but on the facts as presented at trial, it was a reasonable inference that the jury could draw.
But she wasn't 5. It would be very different if she were 5, but with a 9-year-old, that is not a reasonable
How do we
inference.
control this? I mean, in every single case with a 9, 10, 11-year-old, isn't the prosecutor going to be arguing this now?
I would
If we say
suggest
this is
that
okay?
that typically is argued.
Is
This is not an
typically argued?
unusual argument
Yeah.
Oh.
at all.
Could I ask you, as I understand, again, maybe I'm misunderstanding, I thought that Ruffin and its progeny was only applicable when the defendant was specifically trying to get at and introduce evidence of the complaining witness's own sexual experience.
Absolutely.
I'm not aware that a defendant needs to do anything to ask the complaining witness what she's watched on the Internet about sex.
Correct. And there was no pursuit of this. I would take issue with the claim the defendant has made on appeal, was that he didn't know that anyone would be arguing this inference until closing argument. In fact, the prosecutor made very clear in her opening argument that she said the capacity of a 9-year-old and the motive for a 9-year-old. And the capacity for a 9-year-old as to how would she know about these forms of sexual conduct if she had not been exposed to them. So that was flagged at the beginning.
The prosecutor said that in the opening? How would she know about these?
Yes. That was one of her points, that credibility was going to be the underlying issue in this case. And as you assess the credibility, you needed to look at the complainant and ask yourselves how a 9-year-old would have the capacity to be able to talk about these things, and what would be the motive for a 9-year-old to make this claim. And that was flagged right at the very beginning of the opening. And notwithstanding that, and I believe it was because what defense counsel was trying to do was he knew he couldn't get anywhere with the general inference of sexual innocence, and he didn't object on that ground at the completion of the closing argument. What he said was there's no testimony here as to what a 9-year-old would know. And I would submit to the Court there's no testimony for that because there can't be, because it's a very individual thing.
What do you mean they can't be?
Well, I can't formulate a situation or a specialty wherein somebody could say, I can speak with authority within a reasonable degree of scientific certainty that can be quantified and is irrefutable, that across the board in this multicultural nation of ours, or this state, or this county, that absolutely every 9-year-old has complete and total knowledge of all forms of sexual
No,
conduct.
of course not, but you're just making the argument why the influence is not a valid influence, because we don't know.
But
We
that,
don't know, and you know, I don't know about 3-year-olds and 4-year-olds, but we see endless records in our trial courts and on appeal where children of very tender years are exposed to the most extraordinary things. And so my question is, what is the basis for any such influence? Now, if the defendant wants to challenge, if the defendant has reason to believe that there was some other sexual activity,
Or exposure on the internet or
or
anything
exposure,
else.
and, I mean, who knows what a jury may infer? That's different from the state saying you can infer. The defendant may attempt to show this particular child, don't be surprised, ladies and gentlemen, this particular child is 4 years old, 3 years old, 6 years old, 8 years old, 9 years old. In your homes, you may not expect your sons and daughters to know about this, but that's very different than the Commonwealth saying you can infer this, because what child at age 9, I don't know what child at age 9 knows what in our, and then I can go through your list. You know, multicultural, diverse, different, whatever, that you just, it's not an inference that I can draw.
but it's a factual inference that can be rejected. It's an argument that can be rejected by the jury, that because of what their knowledge is of the town in which this happened, that because of what they're hearing
But you
as
can
to
only
what this
argue
victim
based on the
did.
record, and there's nothing in the record to support that. The most you have is that one question about, did something like this happen to you before?
But she was
There's
in
nothing
Florida.
else to support
I don't know
it.
what they do in Florida. I don't know what they did in this home. When you say based on this town,
But if there wasn't a sufficient factual basis for it, then it would be an inference that the jury would reject.
no,
But it
not
doesn't
when-
mean that it's not
no,
a reasonable
when-
argument that can be made. And I think what's happening is the court is looking to almost establishing a presumption, as opposed to, on the facts of this case, given this witness's demeanor, given what you have heard about how this witness had lived while she was in Florida, and maybe the absence of what you heard, and what you heard as to what this witness's experiences were for the short period of time when she was in Massachusetts. Given her age, given all of that, there is an inference that there would be no way for her to know about such sexual conduct had she not had this experience of which she is now complaining.
You rely also on the judge's instruction, and the appeals court strongly, in my opinion, relied on the judge's instruction. But the judge's instruction was more or less a standard instruction to confine your deliberations to the evidence, opening statements, et cetera, on evidence. And if the attorney stated something different in closing from your memory, then rely on your memory. So I don't see that the instruction helps you at all. The instruction wasn't even directed to this particular argument.
Well, and I'm sure it wasn't directed to this particular argument, because that wasn't an argument, an objection that was raised by defense counsel. His focus wasn't there. The trial
So
judge...
you agree that this instruction doesn't go to help you at all?
It doesn't hurt. Certainly, it is not the
It doesn't cure any problem, because this isn't an argument about a memory of what's in the evidence. This is an argument about an inference.
And I would submit that it's an argument about a reasonable inference that could be drawn. What I'm understanding the question to be now is predicated on the fundamental premise that this was in fact erroneous, and that it was unreasonable, and that the judge missed it somehow and didn't correct it sua sponte, and that trial counsel missed it by not flagging it for the court's attention.
Well, the trial counsel objected to the closing argument and objected to this point in the closing argument.
But not for this reason.
What reason did they object for?
He didn't object to the fact that there was insufficient evidence to allow the inference. What he objected to was that there was an absence of testimony to establish what a 9-year-old would want. And I would
Right.
submit
Well,
that that's
that's the
different.
same thing.
I think that's the other side of the coin.
What did you say it was?
Insufficient evidence.
But that's the exact same thing that we're saying.
No, I don't think that that's insufficient evidence in this case as to an inference that could be drawn. He was saying that you needed to get to this point that you required somebody to come in and talk about what a 9-year-old would know.
Well, but the closing argument was that an average 9-year-old wouldn't know this stuff. That was the closing argument. So the only way she could have learned this was if the defendant did this to her. Wasn't that the closing argument? Excuse me.
What am I missing here? I've got the appeals court that says at the close of the argument, the defendant said, I also think that the argument that no 9-year-old would know this, again, I think that's inappropriate argument. There's no evidence before the jury that a 9-year-old might or might not know, and asking the jury to speculate regarding that is improper.
Right.
But that's about as close to an objection that, I mean, that's an objection, isn't it?
It's an objection. Now, he in his, at the end of the prosecutor's closing, he says that his main argument is why would the victim come here after all of these years? That was the main one that he took issue with. And when the judge addressed the curative charge, he said, no, that will be fine. He felt that that addressed the argument that he had and seemingly backed off from it. And I don't believe that's conflating the correctness of the charge and the failure to object to the objection that was made to the argument.
And we have to look at Ms. White's, we have to look at the case that she cited to us. But at least from here, it looks as though there was an objection to that aspect of the closing argument.
There is an objection that he makes as to what would be not the foundation for the inference, but the absence of testimony as to what a 9-year-old would know, which I see as being distinct.
But the argument was that an average 9-year-old wouldn't know this unless the defendant did this to her. That was the argument. And the objection was there's no evidence on that point.
Right. I read the argument as going more specifically tailored to this particular complainant as opposed to globally a 9-year-old. And that may be an incorrect read on it. But what is unfortunate is that when the defendant made his objections, because you had a judge that was trying to be very responsive and to correct any misunderstanding that the jury may have, that this was not pursued further, but rather that the curative charge was accepted as being sufficient, and he didn't press the point, but really went on to say, well, what his main argument was. There was some talk later on about the hallucinations, and the judge indicated how she had understood the prosecutor's closing to be pointed, and defense counsel had stepped back, and they didn't address that except in a very slight issue. It would appear, as from a read from the transcript and from the interplay that went on back and forth, that the judge did not then understand the objection to be as this court is currently reading it. And defense counsel did not press that point. And that's why the record is perhaps not providing sufficient information for this court's determination, at least at first glance, on the record. That being said, and I see the light is flashing, I would ask this court to affirm the verdict of the jury.
Thank you.
Thank you.
All rise. Hear ye, hear ye, hear ye. All persons having anything further to do